The honourable member for Davenport.
Thank you so much, Mr. Speaker. I will be sharing my time with the member for Saanich Gulf Islands, a place I'm hoping to visit sometime soon. It is always an absolute privilege for me to stand in this place and work for the people of Canada, and that is certainly true today. And I'd also say, Mr. Speaker, it is absolutely always an honour for me to rise on behalf of the residents of my riding of Davenport to speak on Bill C-9, an act to amend the Judges Act and the Criminal Code. I always like beginning my speeches with a little bit of a quick summary of what the bill proposes to do and some of the key changes that are being proposed to be made, and then going a little bit more into details in my main speech. So Bill C-9 proposes amendments to the Judges Act to replace the process through which the Canadian Judicial Council reviews the conduct of federally appointed judges. It establishes a new process for reviewing allegations of misconduct that are not serious enough to warrant a judge's removal from office, and it makes changes to the process by which recommendations regarding removal from office can be made to the Minister of Justice. This new process also applies to persons other than judges who are appointed under an Act of Parliament to hold office during good behaviour. The proposed amendments to the Judges Act would amend and streamline the process for more serious complaints where removal from the bench could be an outcome, address the current process shortcomings by imposing mandatory sanctions on a judge when a complaint of misconduct is found to be justified, but to not be serious enough to warrant removal from office. Such sanctions would include counselling, continued education, and reprimands. And thirdly, it would require the Canadian Judicial Council to include in its annual public report the number of complaints received and how they were resolved. Indeed, Mr. Speaker, Bill C-9 is unique. And let me provide a few more details about why, and at the same time elaborate on what Bill C-9 proposes to do. The Canadian judiciary is rightfully held in high regard, and not just in Canada, but around the world. Their decisions carry great weight for individuals appearing before them, whose lives are so directly and meaningfully affected, and for society as a whole. Hold on, I'm just missing my pages, Mr. Speaker. Yes, there you go. Canadians rightly expect much of judges to make decisions that apply the law correctly and fairly, and to do so in a way that embodies unimpeachable character and meets the lofty standards to which judges are held. The confidence of the Canadian public in both individual judges and the judiciary as a whole depends on it. Mr. Speaker, we know that the public confidence is well placed, but neither we as lawmakers nor Canadian society as a whole can become complacent. We all have a role to play to ensure that confidence in the judiciary continues to be merited. Part of that is making sure that Canadians know that there are avenues open to them to make complaints about a judge's conduct, and that appropriate recourses are available. For this reason, processes have been established that allow for such complaints about the conduct of individual judges. At the same time, judges must be held to respond to complaints and be assured that they will be treated fairly and in a way that is in keeping with their judicial independence. For this reason, the Canadian Judicial Council, comprising of the most senior judges in Canada, was created and has the authority to manage the processes by which complaints about judges are investigated. Mr. Speaker, Parliament has had a role to play. Mr. Speaker, Parliament also has a role to play. In 1971, Parliament established the Canadian Judicial Council and charged it with establishing and managing the process for investigating complaints against federally appointed judges. The legislative framework that Parliament set out for the judicial conduct process remains with us, largely unchanged 7 decades later. And today, we've reached a unique point in history. We have before us the opportunity to build on Parliament's past work by modernizing the judicial conduct process, ensuring that it continues to reinforce public confidence. And I urge every member of this House to seize this opportunity. The existing mechanisms used to review allegations of judicial misconduct are in urgent need of renewal. The current process was established more than 40 years ago. Since then, the administrative law landscape surrounding the process has changed. The values and standards that help shape expectations of judicial conduct have evolved too. The judicial conduct process, however, is largely the same. We know that it is out of date and that it demands reform. The Canadian Judicial Council, with its decades of experience running the judicial conduct process, has called for such reform. The Council's chair, Chief Justice Wagner, has identified this as a priority from the beginning of his time in his role. At his welcome ceremony as the new Chief Justice of the Supreme Court of Canada in 2018, Chief Justice Wagner noted the need to modernize the mechanisms for addressing complaints regarding judicial conduct. Several recent judicial conduct cases have highlighted the importance of reform. They've shown us that under the current system, cases can be marked by exorbitant legal fees, lengthy delays, and multiple inefficiencies. This is not a process that inspires abiding public confidence, but today, by supporting Bill C-9, we have a chance to fix this. Mr. Speaker, Bill C-9 addresses the shortcomings of the current process and launches the long-awaited renewal of the judicial conduct process. The reforms proposed in Bill C-9 will make the process more efficient by, in part, preventing parties from seeking judicial review of decisions that are made during the judicial conduct process. This will reduce costs and prevent delays. The bill will also increase accountability by establishing a more robust role for the public in the process. Mr. Speaker, the bill before us today proposes a set of carefully considered, well-informed, and broadly supported reforms. These reforms come out of robust consultations and substantial engagement with the Canadian Judicial Council, which will remain responsible for carrying out the judicial conduct process, and with the Canadian Superior Court Judges Association, which represents many of the federally appointed judges to whom the new regime may be applied. In June 2016, our federal government launched public consultations on modernizing the judicial conduct process. Over the following months, we were pleased to receive multiple submissions reflecting the importance that this process holds for the legal community and for Canadians as a whole. We heard from individuals and organizations who provided thoughtful comments on the existing process and suggested meaningful reforms. The Canadian Judicial Council and the Canadian Superior Courts Judges Association participated in these consultations, as did the Canadian Bar Association and the Federation of Law Societies and members of the general public. These consultations, Mr. Speaker, sent a clear message that there is broad support for reform and modernization of many aspects of the judicial conduct process. The process should be more efficient, more transparent, and provide for greater public accountability. The reforms set out in Bill C-9 embrace this message, responding to the concerns expressed in the consultation process. Mr. Speaker, following the consultations, our government closely together with the Council and the Association on multiple occasions to develop and refine proposed reforms to the judicial conduct process. This close collaboration ensured that the reforms before us today are informed by the experiences of the people who work with the process directly, and the experiences and perspectives of Canadian judges themselves. In conclusion, Mr. Speaker, Bill C-9 sets out changes that are required to modernize and renew a process that is key to public confidence in the justice system. The proposed reforms before us today address a long-standing problem. They were carefully developed. They are widely supported. They reflect the experience, wisdom, and knowledge of the judiciary itself. More importantly, they advance the best interests of Canadians who interact with our justice system. Fellow members, let us work together to strengthen and modernize the mechanisms for addressing complaints about the conduct of federally appointed judges, and to reinforce and foster public confidence in our judiciary and our justice system. Let this bill and its passage mark an important point in the history of the judicial conduct process in Canada. I urge you to join me today in supporting Bill C-9 and passing these long-awaited changes to the judicial conduct process. Thank you so much, Mr. Speaker.